Learned APP has submitted that the CD in these matters have not been received. Accordingly, list the matters again on first week of April. Huh? 8th after election. Huh? 22nd of April. Interim order passed earlier continues. Huh? 49. Okay, Learned Council submit, Learned APP submits that the CD is awaited. You are interim. When? 49 charge sheets submitted. If you are in interim, we'll make it absolute and you go and appear before the trial court as and when you receive the summons. Huh? It has been submitted by the Learned APP that the charge sheet in the matter has been submitted by CS number. Accordingly, the interim protection granted to the petitioner is made absolute. Petitioner shall appear before the Learned Trial Court as and when he receives summon. Yes. What about the charge sheet? 51 to hai ke interim ase ei kori dibo 22/4 55. Yes, you are appearing for the petitioner at the request of the Learned Council for the petitioner, comma, although the TCR has been received. List this matter again on this month. Why not in the first week of April? Huh? You're not here on the first or so? No. Okay, 25th. 25th of March. Yes. At the request of the Learned Council, appearing for the petitioner, list the matter after Bihu, 21st of April. After they have put on the hearing. Yes. 46. The Learned APP submits that the CD is not available. List the matter again on 22nd of April. The interim protection granted earlier continues. 16. At the request of the Learned Council for the petitioner, list the matter again on 6th of April. 43. Are you on interim? The petitioners are on interim protection. 44 and 43, 44, 45. Petitioners are on interim bail. A request has been made on behalf of the Learned Council for the petitioners for an accommodation today. Accordingly, list the matter again on 1st of April. The CD received be retained. Yes. Interim continues. At the request of the Learned Council appearing for the parties, list this matter again on 20th of April, 20 April. The interim order passed earlier continues. 58. Hmm. At the request of the learned counsel for the petitioner, list this matter again on 22nd of April. Hmm. Huh? The the petitioner is on interim protection. The CD is awaited. List the matter again on 23rd of April. Huh? Yes. Huh? It has been submitted by the learned counsel for the petitioner that the petitioner has been arrested during the pendency of this anticipatory bail petition. Full stop. Accordingly, this anticipatory bail petition is closed, granting liberty to the petitioner to approach for regular bail. Huh? 17. Yes. Hmm. At the request. Huh? No. Mr. Parashar, the item which was mentioned before this, was it item 44 and 45? No, what was the item just mentioned before this? Was it 55 or 45? 44. 44 already mentioned. There was already a date fixed. What was that? Hmm? 54 to him close কৰিলো 44 নহয় 54 ক্লোজ কৰিলো মই এইটোতো যিটো হেৰি হ'ল এৰেষ্ট হ'ল 54 এইটো yes you are saying item number 16 17 at the request of the learned counsel appearing for the respondent number 2 with the consent of the counsel appearing for the petitioner list this matter again on 8th of April after Bihu on 24th of April. Interim order continues. 40. Yes. The case there is awaited in the matter. The petitioners are under interim protection. List again on 23rd of April. Interim order continues. 35. Huh? Huh? Yes. Huh? At the request of the learned. Huh? They want a passover for the day. At the request of the learned counsel appearing for the petitioners list again on the 1st of April. The CDB retained in item 19. Item 19 at CDB retained. Huh? 23rd দিলে নাকি 23rd 23rd item number 26 also তাতে খালি CD retain to নাথাকে কোনটো first of just a minute item number 19 the CD has been received learned counsel for the petitioner prays for an accommodation for the day list again on the 1st of April CD received be retained item 26 at likhok the learned counsel for the petitioner has sought an accommodation stop list again on 1st of April yes 4 learned counsel for the petitioner has submitted that he is under instructions not to press the bail petition in the present form. Full stop. Accordingly, bail petition is closed. Without the other party being there, what can we do? Let them come, we'll direct them when they appear. Yes, madam. Hmm. Hmm. We'll call for the CD scan copy. Huh? Call for the scan copy of the TCR list again on 6th of April. Ah, they will write it down. Ah, ah. And you are who? Huh? Yes, madam. We'll grant them an interim list along with this one. Or the learned counsel for the petitioner. This bail application is filed under section 483 of the BNSS, praying for bail in connection with Gopu. Ito pa ilulubo, ha? Bail order to move issue. The case diary has been called for in connection with BA number 759 of 2026. The learned counsel for the petitioner has submitted that the petitioners were the persons working in the vehicle which was transporting the cattle. Full stop. They are neither linked with the ownership of the cattle or of the vehicle. Full stop. Accordingly, this court is of the opinion that the petitioners can be allowed an interim bail so that the investigation in the case can proceed on the right direction. List again on 21/4/2026 along with BA number 759 of 2026. Continuance of the interim protection will be reconsidered on receipt of the case diary. Hmm? Hmm. As a CID officer, yes. Then? Hmm. Huh. Ah. Hmm. What have you given before this code that you have an that the address shown in Orissa is a good address? How from where do we find it? The statement in the petition is okay. What is the documentary evidence to show? Either we call for the scanned copy of the TCR or you furnish some address proof, some verifiable address proof, maybe an Aadhaar card, maybe a voter ID, something that we can ask them to verify from the address. And since you are not from this place, in case we grant a bill, it will be under strict conditions. But we must have an address. We must have some proof. Over the counter is not helping. Over the counter would not help. File an additional affidavit, give them a copy, let them verify the address, whether this person belongs to that place or not. See, he has not only impersonated, he has impersonated the CID. Is it not? Level of thinking is a bit higher. List again on when can you file the affidavit? Huh? When can you file it? We'll list it on Friday, Monday. Okay, on the 23rd at the request of the learned counsel for the petitioner to file an additional affidavit. Yes. Wow. List this matter again with BA number 582 26, where the CD has been called for. Item 6. Okay, huh? Hmm. What time is it? Hmm. Why did we reject it? We'll call for the TCR. Issue notice to the respondent number 2 under the prevalent notification. Call for the scan copy of the TCR. List again on. We'll have it. Hmm. On the 27th of March. Stop. It has been stated by the learned counsel for the petitioner that the TCR has been called for in. If the TCR is received in that matter, a copy of the TCR would also be tagged along with this bail petition. Okay. Item 8. Yes. Ah, you are not mentioned. Atiful, Shahjahan, Azizul, Mohidul. Where is the SMS version? Page? গৰুজনী উলিয়াই দিব বুলি why are you not producing the vehicle? The cow. Huh? But huh? How? You will cooperate, but who is this person? Azizur Rahman alias Polu. Have you seen that order, page 18? Madam, page 18. Huh? Whether he has taken the ground or not, this is a bail. Is it not? For us to do substantial justice. We'll allow him to appear, call for the CD. If we find his involvement, we'll cancel the bill. Call for the CD. List again on 24th of April. The petitioner shall appear before the investigating officer on or before the 26th of March 2026 to participate in the investigation. In the interim, if it is provided that if in the event of the arrest of the petitioner, he shall be released on bail of punishing a bond of rupees 10,000 with one surety of the like amount, subject to the satisfaction of the investigating officer. Full stop. The continuance of the interim protection granted would be considered again after receipt of the CD. Eh? Eh. But where is the cow? Where is it? Huh? It is not recovered. The counsel for the petitioner has submitted that the named accused have already been released on bail. And today also, in an anticipatory bail, interim protection has been granted to one of the to another person regarding the same FIR. Full stop. Accordingly, this court is of the opinion that the petitioner can be granted the privilege of bail to participate in the investigation. Full stop. The petitioner shall appear before the investigating officer on or before, when did I say, on the earlier case? Agar case look at 23rd niki. 26th of March একে দি দিয়ক হা তলৰখিনি একে থাকিব আৰু হা 24 এপ্ৰিলতে আহিব হা Yes, but otherwise you see on the theft is on 21/2026 by breaking the wooden door, and 1 month later he realizes there is a theft. We are granting the interim. This is an application I do a pre-arrest bail under so and so. The Illinois counsel for the petitioner has submitted that the FIR has been admittedly lodged after a month of the alleged incident of theft, which was allegedly done by breaking the wooden door, full stop. The learned counsel for the petitioner has submitted that the petitioners are working for their livelihood in Gauhati, while the theft is allegedly took place in Dhubri. Full stop. This court is of the opinion that the petitioners would be required to appear before the investigating officer to help in the progress of the investigation of the matter. Accordingly, the petitioner shall appear before the investigating officer in connection with so and so PS case number so and so on or before the what did we say 26th of March 2026. In the event of their arrest, they shall be released on bail of on furnishing bonds of rupees 10,000 each with one surety of the like amount respectively. Full stop. Call for the CD list again on 24th of April 2026. The continuance of the interim protection would be granted, would be considered on receipt of the CD. So, item 11. Hmm. Hmm. 17/9/2025. FIR is 17/9/2025. Till now, you have not been arrested. Yes, Mr. PP. Huh? Why? For a bill. Government of Assam. This is not Government of Assam. This is PP. I will tell you what happened, what has happened. There is a certain act, Witch Hunting Act. It debars anticipatory bail. Right? Now, this was filed before. Since there is a bar to filing of an anticipatory bail, there is no other available remedy. A writ petition will lie. When a writ petition lies, it was filed before the division bench. Division bench has given an opinion that it should be listed before the single bench because it relates to bail, which should first be seen by a single judge. Therefore, it is before us. Although it is a WPC, the question is one of bail, the anticipatory bail, and the question is one of investigation being hampered, or it relates to a police case. Hmm. Have it tomorrow? We have to take it up tomorrow without, even if I have to call for a CD, they must have a copy. Friday? Okay. The learned APP has submitted that the copy of the WPC has not been served upon the office of the PP. Full stop. Accordingly, counsel for the petitioners will serve a copy of this petition on the office of the APP office of the APP list again on, you said, 20th Friday. On Friday. Have your instructions also, since you've got time. The FIR is of September 2025. They are the name accused. Allegation is that they had called a lady, tortured her because she was labeled as a witch. She was made to eat feces and other thing. And since it's a non-bailable offense, they are in the writ petition. So when from September till now, they have not been arrested, whether further custodial interrogation would be required or they can be interrogated without custody. Huh? The cause list would reflect the learned APP on the next date of listing, on and from the next date of listing. Yes. Huh? Page 60. Huh. Earlier it was 6,000. 3,000 each. ठीक है. It was total of 3,000. Now it has been made 8,000. हाँ. हाँ. Done. What did you do? What did you do? We are dismissing this petition. Nothing. Yes. Huh? Why did you not say it in the first go? No, but we are not leveling anything against you. We will simply say that we have noticed that despite there being no stay, the petitioner has not been paying the amount directed by the. What was the what you moved a petition? Or should we take it up for disposal today? We'll close it. This way or that way we close it. Yes, tell us. That there should be no enhancement. What is wrong in this order? Tell us. Page 10. Yes. Hmm. Hmm. What? Acute hardship on maintenance business of cycle and Bittlenut, and is a retired army personnel. As pension, he draws 8,000 and used to earn 35,000 from all sources. Is evidence. What was your evidence regarding your income? Huh? Tell us what was your stand. Huh? Huh? Yes. Then you did not give any evidence regarding your income. That he has got a business. Eh, where is the written statement? Where is the written statement? Page 18, 18. Tell us. Oof. Yes. Needs evidence denied during pension. Huh? Hmm. Hmm. So why is she not putting up this order before the department now? The enhanced order? Hmm. No, why should the court be inclined? If you give it to the employer, they won't deduct and give it to you. The court has to give the order. Yes, tell us what is wrong in this order, kindly. We are taking too much of time. What is wrong in this order in enhancing the allowance? Just tell us that, the maintenance. That this is where the court made a mistake. This is revision, is it not? Not appeal. Tell us that this is how it went wrong. You were working as what? You were serving where? You are drawing that pension from where? So he was in the army. He must have been in the army. So be it. So, yes, sir, tell us what is wrong. One week ago, gas cylinder was? Okay. Yes. Huh? It was 2 and 1. 4 and 2, 6. Yes, Mr. Biswas. Two has been made 4. At page 19, the original amount was 2000 and 1000. Either you say or I say, don't interrupt. Running commentary is very irritating. 2000 and 1000. Now it has been increased to 4000 and 4000. So we make it 4000 and 2000, 6000. Huh? The mother also has to put in some effort. Oof. Now, there is no such prayer in the petition for reduction consideration. Yes, let us at, huh? We are disposing it of. Mm-hmm. That was your submission. We'll keep it at 25,000. We'll hold it to be 25,000. No, that was your submission. That was your submission. It is submitted. We'll not go by your submission. We'll go by what has been stated by him in the affidavit, in the written statement. And since nothing has been pointed out to this court, why this court should exercise the revisional jurisdiction, we dismiss it. Yes, sir. One more opportunity. One more opportunity. Show us why we should exercise revisional jurisdiction. Show us. Yes, now. Why? Huh? Oh. When can we exercise revisional jurisdiction? When can we exercise revisional jurisdiction? When there is some. See this petition is being used as a instrument not to give the dues to the wife and the child. That is not what criminal revision petitions are for. It cannot. uh, mm. We don't need it. Unless you can show us that there is a mistake in this order. Show us the mistake in this order. Today is Wednesday. Friday. Okay, Friday. 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 Friday is a good day. The petitioner is put to notice that in case the amount directed is not deposited by the next date fix, court may consider dismissal of the revision petition. It was already there in the earlier order. Mr. A. Divan, learned counsel for the petitioner, has prayed for the matter to be listed on Friday to inform this court as to whether the amount directed to be deposited has been deposited or not. Which one? Huh? We are keeping it at that. We are not recording anything else. 20, no? Not, oh, 20. Huh? Yes, sir. After some time, sir. Hmm. Huh. Where is the petitioner? Hmm. Ah. Hmm. But then in the absence of the petitioner, should we be, we'll have it after some time? Okay, at two koi diyo. TCR আহিছে না এটো? Huh? No, no, the PC. Was it called for? Oh. Huh. Hmm. 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 Add two. We'll try add two. Duke. Item 20. 20. Huh. None appears for the parties on call. List again on the 24th of April. 21. 21. Do we have the report, sir? And also for a report. What does the report say? Anything grievous or some mistake? Hmm. Yeah. So petitioner is not the registered owner of that vehicle. Hmm. No, that part we have understood that the vehicle was seized by the other outpost. While investigating this case, he found that that name of that vehicle has also come up. So he seized that vehicle also in the case. Okay, understood. हाँ, तो इसमें कुछ नहीं है. ठीक है. He gave the name and हाँ हाँ हाँ. Hmm. That we have understood that the vehicle, because it was named by some other person that this type of vehicle is being used or this is the vehicle being used, he seized it from the other outpost. That, what about this part, the last part of that instruction? The petitioner is the registered owner of the vehicle or not. It is unable to be verified as the vehicle was hired from Self-Drive Yumli Lifestyle Private Limited. Yes, you have not appeared before the person. You have not appeared before the investigating officer to take the... you have not appeared. Hmm. Acha. That we have understood. Now the vehicle has been released to you. It has been released. It is in his name. There is no irregularity. He found that the vehicle is named in another case. He found the vehicle in the Thana. He sees it is okay. What we thought was, if the vehicle is in the Thana and you are trying to implicate it in some other case when it is in your possession, how is it possible? Now there is an explanation. So there is no difficulty. There is an explanation how that vehicle came to be. Huh? Where? Okay. That is to your this thing. The huh? But then you should also be careful. This Glanza vehicle, the Toyota Glanza, is for people to ride, not to carry cows in the back seat. That is what is.
Because my instruction was you. Driver did not satisfy the post. That is why they was taken my lord. Or it was my lord.
Heard Mr. Enzaman Learned Counsel for the petitioner, also Mr. Borua Learned APP for the state. The Learned APP has submitted the report called for by this court. And on going through the contents of the report, this court is satisfied that the seizure of the vehicle by the IO of this case was based on the facts and circumstances prevailing at that point of time. Full stop. Accordingly, since the vehicle has been released, this petition is closed by accepting the report produced on behalf of the investigating officer. Full stop. The report is kept on record as and marked as X.
Hearing BM item 22.
What had happened? Just a minute. Hmm? Last order on? Where in the yes, madam, what do you say? Huh? Yeah. Where is? What does the grandmother say? Hmm. 23? 20th of March. See, that is why it is difficult. When we are asking for the TCRs, when the accused is there, one effort from you getting us the certified copies is as good as asking for the scanned copies of the TCRs again and again. 20, no, she said 20th of March. 20 March. So we'll have it on the 24th. 31st of March. Oh, this is from Lakhimpur, okay, huh? So we'll have it on 30 March. 31st. The statement of the victim is not available on the records. The next date fixed in the trial court is 20 March 2023 as 2026 as informed by the learned amicus. Full stop. The learned counsel for the petitioner has prayed for listing of this case on the 31st of March to allow him to obtain certified copies of the proceedings and place before this court. The registry shall also call for a updated scan copy of the updated TCR in the meantime. The statement of the victim under section 183 shall be, BNSS shall also be called for. Full stop. If you can obtain those copies, you get the copies, whatever copies you can for this court. It will be to your advantage. Hmm. Ah. Ah. Yes, sir. The learned APP has submitted that the scan copy of the trial court record shows that the charge sheet has been submitted by CS number. The option. By CS number. Huh? (557) of 2025, dated 24/12/2025. Full stop. The petitioner had been granted an interim bail by the order dated 9/1/2026. Full stop. This was after the charge sheet had been submitted. Hmm. Then on the next date, what happened? We'll make the bail, we'll give the. No, he's already on bail after the charge sheet. He'll keep appear. We'll give, at the condition that he would appear before the trial court on each date, and that is already there. Shall cooperate with the trial of the case. Yeah. We have gone through the trial court records. Step. On a perusal of the above, this court is of the opinion that the interim protection granted to the petitioner on the earlier occasion can be made absolute. Accordingly, the interim protection granted earlier is made absolute, subject to the condition that the petitioner shall cooperate with the trial of in the trial. Stop. Be disposed of. Next thing.
24.
Hmm. Why? Tell us. Reading. In the schools, they ask the students to clean the office. What can they feel? Huh? Hmm. Hmm. Yes, sir. What do you say? Huh? Huh? 21? 21. Huh? PCR reduction. Yes, it is 60 days or 90 days. Ten is 60 days. Ah, 10 is ठीक है. हाँ. Hmm. So not less than 10 years. Then when the charge sheet is containing those sections, will it be 60 or 90? 90 days. Registered under 68 and 62. Ha. So it will be 5. Okay. 5. Hmm. 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 Kerala High Court, what does the Supreme Court say? That is what. Hmm. Used to. Hmm. What do you say to what he is saying? His basic argument is even if it is life, then it will be 20. 20 is half is 10. If it is 10, he is saying it is 10. Huh? Hmm. Hmm.
In cases where the offense is punishable for up to 10 years, the court possesses the discretion to impose a sentence of less than 10 years or exactly 10 years. Furthermore, the honorable effects for clarify that if the offense carries a punishment of less than 10 years, then the matter is totally clear for execution of the 90 days. The court notes that the donor only honorable effects of the judgment in that not just for the years to be as the court will be presented by the counsel for the issue which is based on the Kerala when in school is not obligated adhere to that they believe from the effects for family subject when an offense is punishable by minimum of 10 years. It's a clear for industry to come to 90 days rather than in light of this consideration, the court finds to the cases for supporting the for company the investigator of the days. The solution is considerable under the prevailing legal standard. Additionally, the court points out that judgment from the Kerala High Court cited by the does not address the definition of right imprisonment as articulated. Instead, it is incorporation of
Where from this life is coming into? Why the discussion on the a remainder of the life? It can be 2 years, 4 years, 10 years, 35 years, 45 years. Huh? 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 Minimum of 10 years, then it's 90 days. Where the concept of 60? Huh? Hmm. Kerala High Court has given it, but it can extend to life, but it cannot be below 10 years. Huh? It can extend to 20 years, but it has to be a minimum of more than 10. No, no, what he's saying is something else. It is 20. Correct? The maximum can be 20. It cannot be less than 10. So let us take it to be 11, just for the sake of convenience. The cases of attempt. So what will be half? Maximum punishment will be what? How? If it is 10, if it is 10, it is not more than 10. If it is 10, then it is 60. Huh. The half can be imposed, sir. The half of it can be imposed because it is an attempt. It is not the commission of the crime. It is an attempt to commit the crime. If it is at half, then it is on 10. It cannot be more than 10. It can be up to 10. If it is up to 10, it is 60. If it is up to 10, it is 60. Not your interpretation. Give us the correct. Hmm. Ah. Honorable Court concluded case where the offense is punishable up to 10. The court possesses the discretion to impose sentence of less than 10 years or exactly 10 years. Then, then it is not more than 10, it is 10, right? Now, even if you go by the other part, not less than 10, it has the half will be less than 10. Either case, it is less than 10. Either case, it is 60. If it is 60, he gets the bail. Yes, Mr. Parasar. Are we understanding it in a half will come to 10? 10 is 60. Is it not? The minimum is not less than 10. Whatever you take above 10 and below 20, the moment you half it, it comes below 10. Huh. Hmm. The court possesses the discretion to possess a sentence of less than 10 years or exactly 10 years. The court clarified that if offense carries a punishment of not less than 10 years, then mandatory statutory will be 90, not less than 10 years. But if it is up to 10, the last date, even then it is 60. Then
It may be 10 years also.
even then it will be 60. And if you go by the other part, the punishment has to be now between 10 plus 1 day to 20. Is it not? Half it. Can it go beyond 10? No. So it is 60. You forget the other part. It can be up to 10 or not, you forget it. The punishment has to be from 10 plus 1 day to 20 years. Is it? Half of it. It cannot be more than 10 years. If it is 11, it will come down to 5.5. 12, 6. Go on. 20 years. Maximum you can give is exactly 10 years. 60. Default bail. You are not even being able to draw support from your own flanks. What can I say? Ha. Okay, that exactly 10 is what we will discuss. For the present, we feel that it is a default bill case. And if that be so, no option. And after going through it, if we feel that there is something different, we'll have it listed to be spoken to. If we are convinced by him, we'll give you another chance. এইটো হেৰি কৰি থক CAV কৰি থক CAV কৰি থক কাইলৈ ৰাতিপুৱা দি দিম No, the day it is presented to the court, that is the day I will take it to you. Ten, it is 10, it is not 9. Ha, we can't go. 2910 is what you say, na? Order dated 2910 says, I have submitted the charge sheet. We don't need to read any other order. So, charge sheet was submitted on 2910, beyond 60. এইটো default কাইলৈ ৰাতিপুৱা order দি দিব
24.
এইটো কি দিলে মোক 24 টো হৈ গ'ল এইখন তাত বান্ধা এইখিনি। Yes. Ah, if you don't have the FSL report, show us a photo of what was recovered.
They have done the minor.
Saying
Done the it is the year for the
person is behind bars 2 days, 62 days. If it is not a pistol every day, eh? Unless the FSL says so. No, the FSL will say whether it can fire an ammunition or not. Otherwise, in the villages, you are making it out of bamboo also. That cannot become a pistol, can it? That will not come under the Arms Act. Huh? Otherwise, catapults and all, they will all come under the Arms Act. You know. There is no allegation that it was used anywhere or anything. Document of what? Handmade firearm. The learned counsel for the petitioner has submitted that the petitioner has completed 62 days behind bars. Full stop. It is noticed that despite repeated opportunities, the FSL report regarding the nature of the alleged handmade firearm has not been produced before this court. Full stop. Keeping in view the fact that the petitioner is a mechanic who earns his daily livelihood by working in the garage, and in the absence of any report till date regarding the nature of the arms, this court is of the considered opinion that the petitioner deserves to be released on bail on furnishing a bond of rupees 20,000 with two sureties of the like amount to the satisfaction of okay till the next date fixed. Full stop. Ordered accordingly. List the matter again on. We'll have it on the 20th of April, awaiting the FSL report. The continuance of the interim protection granted would be subject to the FSL report. 20 April. If you can give us the FSL report that it is a firearm, we can sell it. When will the 90 days be over? 2 days? Huh? Then we'll have it on the 10th. Friday, 10th of April, Korok, huh? 10th of April.
27.
Age 20. Just a minute. Just a minute. So 18 years. Date and time of seizure. PM. Afternoon. PM is afternoon. How do you know? Just a minute. From where do we find the morning part? You should take us that. Today at 9:30 a.m. Involved a two-wheeler, so and so, so and so, so and so, suspected subsequently, so and so. Wicked identity cards set up. This is on 15/3. Ah, just a minute. On 15/3, so and so. During sport. What is your name? Tanjil Abedil. Ah, now just a minute. Page 18. They reached back at 15/3/2025 at 4 p.m. And when were you produced? Page 31. Yes. Mm. Where, where is it? Huh. Some record to. Tolo. There are two petitions. Where have you checked the record? What is that? এখন কি next case to niki? Nobody. Have you flagged it? No. Where? Which page? Where is it? GD. Where is the GD? Hmm? You have flag mark? No. GD part can you can deduce. That we will see. 47, 48 we will see. You the accused, they do not tell whom to serve, then they come and say no one served. And that part is a separate issue. Kindly show us this part. So heard Mr. So-and-so learned counsel paying for the petitioner, also heard Mr. So-and-so learned APP. The this is a bail petition praying for bail under so-and-so to দিব, huh? তাৰপিছতে সেইটো প্ৰতিটো কেছতে দিব। As per the FIR lodged on 5/3/2025, the proceedings of search, etc., were started at around 9:30 a.m. in the morning of 15/3/2025, and for the same FIR, that is why we do not give the records. Now it has gone and tied with someone else. এইটো 2টা বজাত মাতক, এইটো 2টা বজাত মাতক। এই যে এটা যে ক'লো যে কালি অৰ্ডাৰটো দি দিম বুলি, ইয়াৰ আগৰ কেছটো যে বিলটো, ডিফল্ট বিল, হা সেইটো, হা এইটো তাত ভৰাই থকচোন। এইটো 2টা বজাত টেক দি ৰেকৰ্ড। There is some record here.
28.
At 2. We'll take it up at 2. Huh? No. Excellent. We'll come back. We'll just come back. Time being কৈছিলে দেখোন এইটো। আগতো মাতি দিওঁ। Ah,
27.
what 27 then? At 2. 27 to 2.
29.
29. Yes. Ah. Ah. You said that case, there is no order from me as to what case. So you must be mistaken when you say it is by some other case. By me. Where is that order? Page 80. But it has come by an order that listed before another bench. Yes, what is the matter? Hmm. 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 Where is it? Where is it? Those two bail petitions you are saying? Hmm? You do not have a copy. Hmm.
on the text and that this with this one is another petition also listed on that folder, Lordship. Death sentence, Lordship. I 2,026, Lordship. And your Lordship, that petition was allowed to go on there by that sentence. Number 330, I have listed. Page number 7.
Huh?
Granted there. Your Lordship, paragraph number 4. This contended that there has been clear violation of the mandate of section 48 unit requires institution of the ground of marriage being license to the family members, friends, nominated person of the
Yes, what do you say? Huh? 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 No, no. When it was rejected, where is the rejection order? Huh? Now you come to this part. Just a minute, madam. Just a minute. Now, when it was rejected on that day, there was nothing before the court to show that it could not be, that there was a report that it could not be served because it was a disturbed area. Huh? But you do it. You talk to him. You have a discussion, roundtable discussion, and then you do it. Listen to her. She's telling you what to do. So now in different cases, this court has held that if it could not be served, it could not be served. Matter stands at that. Now in this order by which it was earlier rejected, there is no proof of service, but also there is nothing on record to show that it could not be served. That is what you have to tell us. WT message was sent. Now you do not have a copy of the additional affidavit. We'll take it up at 2. Go through the judgments which have been given by her in the additional affidavit. At 2 we will see. This case, in this case, you listen, counsel, Miss Medhi, give her copies of the additional affidavit because this matter again after on when on 24th of March, allowing the learned APP to have. Yes, you want to give copies today and have it at 2, or you want to have it on 24th? Give her the copies at 2. Everything, give it to her. We will take it up at 2. Next. 30. Yes, sir. हाँ. Without the oil. Oil, it is now all over Assam. In different vehicles. You will not be able to recover the oil. Huh? Where is the FIR? No. The stealing part will come. Only on the under the attack, not under the usual BNSS. You are for Papu Gupta. Who is Papu Gupta? Okay. Case diary not received. Tanker recovered. You need him for further custodial interrogation. He will not be able to give you the vehicle numbers. Huh? That is okay. Co-accused is from where? What about the 35 notice? Huh? It was observed in the last order, 35.3 BNSS. Hmm? Huh. So if that is the story, then he has neither stolen it nor he has sold it. It has to be the other fellow. Who? What has he said? Papu did it or Raju did it? Huh? Uh, heard Mr. S.M. Abdullah Leonard Counsel appearing for the petitioner also heard the Leonard APP who has submitted that the case diary has been received. The Leonard Counsel for the petitioner has submitted that the oil tanker. The Leonard APP has submitted that the oil tanker has been recovered without the oil. Full stop. The Leonard Counsel for the petitioner has submitted that the petitioner has spent 53 days in custody and it remains a fact that he had handed over the truck to the other co-accused since he was ill. Full stop. Having gone through the contents of the CD and the length of the detention as well as then length of the detention, this court is of the opinion that the petitioner can be granted the privilege of bail at this stage. Full stop. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 20,000 with two sureties of the like amount subject to the satisfaction of CGM Gulaghat. You'll have to put some conditions. Huh? There are some conditions. He will participate in the trial and all that. I'll give you that. Yes. 220 days. TCR received? No. Huh? TCR received. Yes, tell us. Carcass of what? Huh. Hmm. Along with the dead deer. And you allowed that. Huh? Uh, hmm. Huh? You are from Dimapur. Huh? Lady was carrying it. Hmm. Oh, the deer was already dead when they got it. Someone else killed it. They did not hunt it. They did not hunt it. Huh? No, they said for consumption. For consumption. Yes. They should be behind bars during trial. That will be for that will be for conviction. Hmm? Heard the learned counsel appearing for the petitioner also heard the learned APP who says that the TCR has been received. The charges have been framed and the evidence is yet to start. Full stop. The allegation in the FIR is that the petitioner, who was an auto rickshaw driver, was carrying a dead barking deer along with the another occupant when they were intercepted, huh? With the accused number two, when they were intercepted, full stop. There is no allegation that the petitioner was involved killing of the either in hunting of the deer or that he was no allegation that he was either को काट दीजिए killing of the deer full stop. In the circumstances, this court is of the opinion that the petitioner can be allowed to the privilege of bail during trial. Accordingly, the petitioner shall be released on bail on furnishing a bond of rupees 25,000 along with two sureties of the like amount, at least one of whom shall be a resident of the locality of the shall be a resident within the jurisdiction of the learned trial court, and one of whom shall have immovable property in his name. Full stop. The petitioners, the grant of bail shall be further subject to the condition that the petitioner shall participate in the trial as and when required without fail. The learned trial court shall the learned trial court shall be at liberty to impose such other conditions as may be required to ensure the participation of the accused in the trial. Be disposed of. Yes. The TCR has been received. The learned APP has submitted that the service of notice on the respondent number 2 is complete. However, none appears for them. In view of the above, the Namdev MK Bora, MK Brown, Miss MK Brown is appointed as the amicus to defend the interest of the informant and the victim. Full stop. A copy of the bail petition be served on the learned amicus during the course of the day. List the matter again on. We'll have it 24th, 23rd, 24th, 24th of March. Same order, America's school. America's study day. Huh? 24th March, but America's isn't Dukes. Matigo Parne. Other earlier order will be the same. PCR received and notice complete. Mr. H. Buragohai. Huh? Mr. H. Buragohai, you give a copy. List again on 24th of March. Hmm. You repaired. Should we take it up after some time? We'll take it up after some time.
Bye.
Yes. Huh? Huh? Hmm. Hmm.
Bag attached to the body.
Hmm.
My submission is that the bag was inside the train. He came out without the bag. The police apprehended and somehow connected. We have even asked for the CCTV footages from the concerned department, my lord.
Hmm.
And they say that if there's an order from the court, we can give, otherwise we cannot give it. Even I have got that letter on record, my lord, by filing an editorial. This is one. Two, kindly come to page 21. My lord, this is the notice under 48. And my lord, this says, it bears the signature of the accused, but not the signature of his family members. It is written some SD Kundan Kumar. And they say that.
Where is it?
To
Huh.
some WP message.
Huh.
There is nothing on record to show that the WP message was sent to the police station. He has actually delivered it to the person concerned.
Hmm.
Because, my lord, recently in 2026, my lord,
Hmm.
the Chaturda Kumar Angiri, my lord, the Honorable Supreme Court passed some directions. One such direction was that the notice, now this is in relation to notice under section 41A. First, both are in pairing, at the end of the day, both are notices, even to the accused. In categorical terms, the Supreme Court said this WhatsApp business will not be. It has to be actual service in terms of CRPs.
So, I'm just trying to understand. A person from Jammu goes to Chennai, commits an offense, not to be arrested. How?
47 notice given to the accused.
What about the 48?
They can arrest subject to compliance for 48. They will arrest, they may send a intimation to the nearest police station that police officer will serve, that's an actual service. But of this WhatsApp may have n number of problems.
Is it WhatsApp?
This is WhatsApp. This is exactly what they say. My lord, kindly read para 21. Clearly written.
Page 21. Where do we say WhatsApp?
For hereby inform that techniques for such and such, son of such and such, has been arrested in connection. It is to inform that the notice of information of ground of arrest of clearance has issued to you via WhatsApp.
Continue.
Via WhatsApp on your mobile number such and such, and a WP message has been sent to the Go police station for informing his family members about his arrest.
Ah,
Yes.
now we need to know this WT message sent to Gauhati police station. Yes, madam. That would be very dangerous if you are having the page numbers of the case diary. Huh? Kindly show whether the WT message was delivered to the person concerned. That's it.
Six.
Yes, sir. Notice. Ah. Hmm? Scan copy is not shown on 13. If the service is complete. Is the service complete, sir? List again on 20. He is hospitalized. On 23rd, for report of service, comma, a full stop. The office note dated 13/3 reflects 13/3/2026 reflects that the scan copy of the trial court record had not been received till that date. Registry to update the office note after verification whether scan copy has been received, since the petitioner submits that upon inquiry at the trial court, they have been informed that the scan copy has been sent. Yes.
37.
Huh? That he will find. That is we have said that. Hmm. CD received, sir. 32 days. Few more days. When? Tell us when. 31st? Huh? List again on 31st, awaiting the case diary.
Okay.
Hmm.
Forwarding.
Hmm. 1818. Okay. Huh. You have the charge sheet number. They have a charge sheet number. Huh? Charge sheet number? Polgosia PS case number 1 of 2025. When was it given? When was it submitted? Have it confirmed once, because they are saying that today they were informed that the charge sheet is not available. At 2, have a confirmation. Because they might have sent it, it might not have reached the court. We don't know. We have seen instances like that. Huh? At 2, we'll have it.
39.
1-3. Hmm. 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 Okay. Yes, CD. What happened to the CD? FSL report. Yes, sir. Hmm. We'll await the FSL report. 27th, on 27th, awaiting the FSL report. Case diary has been received and be retained. 27th. Hmm. 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 Hostile. Disseminate. Hmm. Yes. Hmm. Hmm. Yes. You don't have any objection to their release. The victim statement in anger pushed and pulled. Touch here and there might have been there, but it does not seem to be an attempt to assault sexually. It is a plain simple assault. Ah. Hmm. Heard Miss So and so learned counsel paying for the petitioner. Also heard the learned APP. Mr. So and so appears. Your name J.K. Roy. J.K. Roy appears for the respondent number 2. The trial court records have been produced. The The evidence of the PW number 1 and PW number 2, namely the informant and the victim, have been already recorded. They have been declared hostile. The learned counsel for the respondent number 2 has submitted that they had moved an application showing no objection for release of the petitioners on bail, since they are all related as cousins. Stop. Having regard to the facts and circumstances above, this court is of the opinion that the petitioners can be allowed the privilege of bail. How many? One petitioner. The petitioners can be allowed the privilege of bail, provided they attend the trial proceedings. Stop. Accordingly, the petitioners are directed to be released on bail on furnishing bonds of rupees 20,000 each to the satisfaction of the learned, with two sureties of the like amount. Two sureties of the like amount. Full stop. The petitioner shall participate in the trial proceedings. Learned trial court shall be at liberty to impose such other conditions as would be necessary to ensure the participation of the accused petitioners in the trial. Making mountains of molehills.
Item 41. 41.
CD is awaited. List again on 24th. 24th of April. Interim order passed earlier to continue.
Supplementary cause list, item 61.
Hmm? Oh, would it be difficult in the afternoon, sir? She must be on her way from Shillong. Otherwise, your submission is that they. Huh.
Just page 24 one. Just
24.
already examined. I have started. Item 8, examined. These are the same page 24.
Oh, they're going to Mumbai by train and all that, yes. This was listed a few days ago. Hmm.
So related part
Done.
not affect the accused located physical relation.
Hmm?
Page 25, last part one.
This is what we had seen. She was taken in a train. Nothing done. It was perhaps from, it was voluntary to one extent, and thereafter, after coming back, something went wrong. We'll have it at, she is praying for 3 o'clock. Otherwise, we've noted your.
62.
Yes. HSLC. And we had also asked you to verify that part. है ना? Hmm. That name is little here and there. Ah,
He has been transferred to alia.
okay.
Now that he has handed over that data to
Some other person.
Mr. Intel madam, responsible to take another extra madam investigation.
Hmm.
Because it's under the date. So the years back to sometime.
Now here what has happened is this is B or AB? B. But huh? Yes, instructions on the age of the petition at the time of occurrence of the incident. है ना? Now, when was that? It was recorded during 2022-2023. And when was it uploaded? Huh? Huh? Hmm. You see, he had made the photographs. So that he is born in 2006. 18 would be 2004. Now he has taken the photographs in 20 to 23. So he's juvenile. Nothing to do with. You cannot hold him now guilty of a POCSO act of committed then. Now they say that in the FIR, started torturing and threatening complainant daughter mentally and also viral her private photos and videos in a WhatsApp group. Yes, why the viraling part? We were considering the
I am
hmm? Huh? We should have. Hmm? Today's Monday. 5 days. He will complete what? The investigation? No. He will give that information. So the CD will not, so the CS will not be there. Then what are the sections involved? Oh, notice not issued to the respondent number 2. Hmm. We'll appoint a amicus. We'll appoint an amicus. We'll take it up on Friday. Huh? Hmm. Amicus is in Bhattacharjee. D. Bhattacharjee is on a Huh. No, we'll have to take the opinion of the amicus only on the issue as to whether the POCSO would come in. If the POCSO does not come in, then the appeal. Viraling something using a WhatsApp. We'll ask him not to have any social media, but otherwise, he is now 19 or 20. Is it not? Are we not spoiling that career more? Huh? there are certain age groups where when videos and photos are circulated by majority of the kids, young people, they circulate it. Would they put them behind bars for 40 days, 60 days? Can that be the level of punishment? Okay. This court has noticed that the offense alleged is of the year 2022 and 2023. The petitioner has produced documents to show that at that time he was a minor. Full stop. In the above view of the matter, this court deems it fit to appoint Mr. D. Bhattacharjee, learned counsel, as the amicus to assist this court. The learned counsel for the petitioner shall furnish a copy of the petition upon the learned amicus. Let's list this matter again on the 28th. Oh no, what is the date? 23rd of March. Item number 56. Mr. So-and-so and a counsel appearing for the petitioner has submitted that has prayed that he may be allowed to take fresh steps. Accordingly, the petitioner is allowed to take fresh steps on the respondent number 2. List again on what is that matter? This is matter, then you'll get 4 weeks time. 22nd of April 2026. Okay,
for a lordship, because the judgment, the order was passed by a lordship. This application under section 151 CPC is being necessitated because of the fact that a number of petitioners who have been arrayed as petitioners were not supposed to be arrayed as petitioners. It is all because of the mistake on the part of the councils. Your Lordship, here, the present applicants are the landowners who are having their lands which have been utilized for the purpose of construction of Indo-Bangla border, road and fencing. And their lands have been acquired by draft award number 2 of 2008. Lordship, I have enclosed the draft award number 2 of 2008 at page 96, Your Lordship. And the petitioners, the applicants, the present applicants are the landowners in connection with this draft award number 2 of 2008. Your Lordship, all these landowners who are the applicants are, they were shown to be the petitioners in connection with the earlier writ petition. Your Lordship, the earlier writ petition was disposed of by a Lordship on
Mhm.
23/9/2025. I have enclosed the judgment, which is at page 156 to 27, at page 272. Your Lordship, the judgment is there. The names of the petitioners are from 156 to 271. Here I have made a statement to the effect that, Your Lordship, these applicants who were shown as petitioners at serial number 89 to 465 May I take a lordship to page 90 at para 3 of the present application, wherein I have stated, as can be seen in the above judgment and order dated 23/9/2025, the names of the applicants have also been shown as the affected landowners in connection with award number 5 of 2007. Has a lordship got it? The names of the applicants can be seen from the list of the
So
petition.
what I have understood is that there were two sets of awards.
Two sets of awards.
One was
One is-
2 of something and one was 5 of something.
Yes.
Now, all
Five-
these petitioners, they joined in into that writ petition which concerned the award number 5.
Yes, yes. 5
Now
of
when-
2007
Ah.
is 5 of 2007 is pertaining to WPC 74 of 2019.
Which is an issue here.
Yes, yes,
You want the names deleted so that you can file a fresh writ petition
yes,
with regard to the persons who were affected by the award number 2 of 2007.
yes, yes. That's the thing. Is lots of.
But then the entire, we'll have to also see the record whether the statements made on oath that these were all, that all the parties were affected by that order and all this will complicate the entire issue.
That's why we have filed the incident application. Lots of. This draft award number 5 of 2007 is pertaining to only.
Let us, can it be done this way, sir? Let us have this matter on the 6th of April.
6th of April. All right.
Because I'll be physically there and then I can also go through all the records and pass whatever orders are required. It's a
Alright.
week or two from today.
Lordship, this draft award number 2 of 2008 is at Annex 1.
We saw that.
Yes.
But what we have to now see in the original records, if we ask for deletion, will it have any effect on the repetition, the statements made in the repetition? That is all we want to verify once. So we'll have it fixed on the 6th.
6th of.
Yes, madam, you want to say something?
6th of April. Lordship, whether it's required to issue notice?
I will issue notice. No, there's no problem. You can give a copy to madam. I think any other respondents.
It's only for the purpose of deletion of the names of the present applicants from the list of the petitioners in the earlier writ petition.
My
Who are
lord,
the respondents here? Yes, madam.
yeah, I am for respondent number 4 in this case. Then the present IA is not maintainable in its present form and style because the writ petition had already been disposed of by this honorable court on 23/9/2025.
Interlocutor applications are not maintainable.
Yes, the case cannot be reopened by way of a IA, my lord. That is my submission today.
So we'll do one thing. We'll issue notice today. You have your objections ready. We'll fix it on the 6th.
Yes, my lord.
We'll hear it. That'll do, sir?
All right. 6.
All right, heard. You take it on. Heard, so-and-so, senior counsel. Assisted by? Also heard. So-and-so, who appears for the respondent number 4. And who else appears?
Respondent number 5, my lord. Tilam Siaba.
And issue notice on the IA, allowing the respondents to
Lordship, I am appearing for the respondents 1 to 3, state respondents.
respondent number 1 to 5 are, since the respondent number 1 to 5 are represented, formal notice is dispensed with, extra copies within a period of 2 days. List the matter again on the 6th of April. Yes, we'll have it on the 6th, sir. We'll try to decide it.
I'm obliged.
Yes. Thank you.
Obliged.
Item 13, finding item 13. 13.
Yes. Huh? Which connected matter? Huh? 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 Okay, can I take a mention when there is a senior bench for listing? Mention it tomorrow morning there for listing tomorrow itself. When there is a senior bench, I cannot take it up. Had it been this bench only, we would have considered, but with the senior bench, we cannot. Yes, item 13. Hmm. Ah. Ah.
Then the return, what happened was that the completed and filed it prior to the secretary for the like, prior to that thing.
Hmm.
So after realizing the mistake, he had filed an application at case 24.
For withdrawal.
I think his judgment of the effect of
Hmm.
for minor tech ID case 20.
Page 20? Huh.
Certainly, that your owner may kindly permit the complaint to withdraw the case of subject to complaint. After concluding the delay and further, the officer for office in order to enable the complaint to proceed the case in respect of justice.
Huh.
So he sought to withdraw affidavit, allowing him to confirm the delay.
Huh. Huh.
Relevant part is on page 29, para 8.
Huh.
It says that paragraph 41. Page 29.
Huh. It was allowed to be withdrawn. No liberty then.
Page 29, judgment of effect.
Huh.
Although had allowed the complainant to resolve the case, but the liberty was not granted.
Hmm.
Although I specifically state that we were that to allow me to file an application for by controlling the visa.
Huh.
So that was not granted by the other side. So agreed by the order that is 72 into I report this court. Although the petition was allowed, but if your pilot tech ID peruse page 29, the paragraph 41 of the ethics code terms.
Hmm. Para number?
Para 8, present para 8, 29.
Hmm.
Now, since the answer to question 1 is in negative, we observe that payee or holder in due course of the check may file a fresh complaint within 1 month for the date of the decision in the criminal case. And the event delay in filing complaint will be treated as having been condoned under the proviso to clause B of 142 the NIA. The direction shall be deemed to be for all such pending cases where a complaint does not proceed further in answer to question 1. As we have already held that the complaint filed before the expiry 15 days for a date of receipt of notice 200 cross C, the provision to 130 is not mentionable. The complainant cannot be permitted to present the same complaint at any later stage. Remedy is only to file a fresh complaint and leave the same. Could not be filed.
Mm. What do you say? Huh. You did not even the delay condonation will not be on the that observation may not come in this order. Oh. Sir, when there is no petition pending before the court, what delay does it condone? You made a prayer that you may be allowed to file a fresh petition by condoning the delay. The fresh petition, the order has to be passed that the delay has been condoned. You never filed a fresh petition. You file a fresh complaint. You give the reason that this is the since we had approached the criminal division. Hmm? Heard Mr. Swenson under counsel appearing for the petitioner also heard. The under counsel appearing for the respondent. The grievance in this petition is that the learned trial court, while allowing the petitioner to withdraw his earlier complaint, which was filed before the time frame given for filing of such petition, was allowed to be withdrawn, comma, there was no observation that the delay in filing a fresh petition would stand condoned. The learned counsel for the petitioner has referred to the judgment of the apex court in Gajanan Burange versus Lakshmi Chand Goel, page 27, reported in so and so to impress that in such situation, the delay in filing the fresh complaint requires to be condoned, subject to the conditions mentioned in the order itself, full stop. The learned counsel for the respondent has submitted that the petitioner did not file any fresh complaint, and therefore no occasion arose before the trial court to consider the condonation of delay in filing a fresh petition, full stop. In view of the submissions made and having perused the orders passed by the apex court, this court is of the considered opinion that it is only when the petitioner would approach the learned trial court to file a fresh petition, a fresh complaint, that the trial court would have the occasion to consider condoning the delay, if any, full stop. Accordingly, this petition is closed by allowing the petitioner the liberty to approach the trial court by filing a fresh complaint, and in case there is any delay, the same shall be considered by the learned trial court on a prayer made by the complainant in accordance with the law laid down by the apex court in Gajanan Burange Supra, and also keeping in view the fact that the petitioner had approached this court by filing this criminal petition, full stop. Did you file it within a month? Then with the aforesaid observations, this criminal petition is closed. We are closing this. You go and approach. We observe that this petition will also be taken into consideration while considering delay. Yes. Dear.
61.
Yes, Ms. Agarwal. What do you say? Ah. Huh? Huh? It is not? Huh, and you will also see that she was traveling by train and all that. Nothing done at that point of time. So it is only after she came back, maybe some pressure to heard Mr. H.I. Chaudhary, Learned Senior Counsel, assisted by Mr. So-and-so, Learned Counsel appearing for the petitioner, also heard the Learned APP and Dr. Agarwal, Learned amicus appearing in the matter. The scan copy of the TCR has been received. The Learned Counsel have been heard. On a perusal of the trial court record and the evidence recorded so far, this court is of the opinion that no prejudice or threat would be caused to the ongoing trial in the event the petitioner is allowed to avail the privilege of bail during the trial proceedings, full stop. Accordingly, it is directed that the petitioner would be released on bail on furnishing a bond of rupees 30,000 with 2 sureties of the like amount, and subject to such other 2 sureties of the like amount to the satisfaction of the learned trial court. Learned trial court, we'll say the learned trial court. Learned trial court. Full stop. The learned trial court shall be at liberty to impose such conditions upon the petitioner to ensure his presence during the trial. Full stop. Bail petition stands disposed of. We'll put in 1 or 2 more conditions regarding the bailers. 1-4. Yes, madam. Huh. Huh. Hmm.
The Revisional Act filed by the opposite party, wherein it held that in a matter under the NIN, 7 days delay in filing a complaint is minimal and remanded the matter to legal trial. The Honorable Supreme Court said that the Limitation Act is not valid. The NIN.
Huh.
It appears 2014-11 SCC 769 and paragraph 34 thereof. Can be different.
Hmm.
Part takes 130 of it. Wherein this delay is the admitted delay of 7 days filing. And my lord, I also have another ground that the allegations in the complaint do not constitute the offense as alleged in the light of prosecution, a judgment by law. Allegations even if considered their fact.
Where is the judgment shows that the delay cannot be condoned? The delay cannot be condoned. Itu soal ID option. Itu soal ID option. Para 30. Yes, then how the delay could be condoned? Yes, sir. Just a minute. We'll go stage by stage. If one satisfies, then why the other one?
I think 142
Hmm.
been inserted in 2003.
Hmm.
Whether this
14.
14 doesn't need the but the that's taken into consideration that provider itself
142
42
B.
B.
B, yes, it has been taken into account. 142 B has been taken into account. Or we take it up when? You go through this judgment. And what is your other ground? Hmm.
That the Honorable Court has said it cannot be taxation. This is in 2025 India Supreme Court,
Take a note.
1133.
In view of the earlier judgment of this court,
Uh,
Washington,
uh.
this included by the principle of issue.
Paragraph 8.
Yeah. It has been earlier.
Maybe, but.
It has been discussed. But the other hurdle you have to now cross. Huh?
2025. From the aforesaid reiterated pronouncement and the principles propounded by the courts, the position of law that emerges is that the notice demanding the payment of the amount covered by the dishonored state.
We'll have it on the 31st, madam. 31st. Let him go through the judgment that you have given. We don't want him off guard. What is it? You are from this. No, it's a separate judgment. No, here is a case, the one that you've given. There, the plea of delay is taken up for the first time before the High Court. In your case, it was taken up there.
They are in the complaint.
It is what. So therefore,
The 7 days delay is there.
yeah.
Then all these things, they have taken for the first time before the High Court in the earlier working petition. The summons was received by the accused in December.
7 years they did not participate and we're going round and round. Yes, fortunately we have read those lines. but we'll take it up on the 31st, which is of this month. 31st, it's a Tuesday. Or your choice, take a date. No issues. First week, then it will be on the 7th. 7th of April, sir. April. His convenience. List taken on the 7th of April, allowing the Learned Counsel for the respondents to go through the judgments relied upon by the Learned Counsel for the petitioner. The interim order granted earlier shall continue. Huh? After some time.
28.
Ah,
48 sent line WC Milo, that it was received, it is not there. Thereafter, Milo, that arrest memo, Milo, it was respect, Milo. No weakness. Udar and page, Milo. Page 51, Milo.
page 50.
According to case, sorry. There are two accused, Milo. One pertains to 50, the other is 51. This is arrest memo at the top, another wrong section may have been.
Huh?
Arrest memo at the top,
Hmm.
736. And the signature of witness blank.
Yes.
Same is the case since my lord, so far as 51 is concerned, other accused.
Scene
Then
47, 10, Rati 11. What is the FIR?
here is case 15,
15.
20.
20.
360 grams of Yaba tablet from the out below the PDL. Nothing was from Eric Milo, from source of stage 20.
Page 47, 48.
The last paragraph of case 20,
Hmm.
Milo. 4 lines from the top. There, after I started conducting vehicle charge. Total count of tablets was 3,564.
Hmm. 48.
Regarding 48, page
Hmm.
54 and 55, madam, by WT, running on record, that it was received.
Yes, sir. Mr. Burwa.
Yes, after this,
Huh?
when the suggested opportunity, I know when they were produced on 11/10/2025.
11/10/2025. When? What time?
December 26.
What time? What time were they produced? Now, when the technicalities come, no, when the technicalities come in, it becomes difficult because you see the FIR at page 23. It shows that they were taken into custody sometime at 2 o'clock in the afternoon.
Arrest memo said 10 o'clock in the morning.
No. It says 11 p.m. in the night. 11 p.m. 10:10. Is it not? Now, if you look at the FIR, they were intercepted at 2 p.m. So there is a 9 hours difference. Therefore, I wanted to know when did you produce them? If they were arrested at 2 and you produced them at 4 o'clock on the next day, 24 hours gone. The GD entry would be there, huh? When the GD entry would be there. And otherwise, 48, was it served? Then you have to tell us that it has been served. You have to tell us that Sribhumi made an attempt to serve. Could not be served, was served, not served. Something? Huh? They did not take that point. So law of estoppel. Yes, sir, law of estoppel. Huh? Law of estoppel will come in. It is not there. The arrest memo witness is not there. Then in 48, the scan copy had been called for. Did you go through it? Section 48. Whether there is anything to note that yes, it was attempts were made to serve. No. How do we know it was sent? Where?
Page 54.
Page 50.
In signature method, inform to WP, page 54 method, signature. Corresponding part method. Inform to WP S number so it. So dated 10/10/20.
So you arrested him at 11 p.m. You must have sent the WT at 2 o'clock in the night. You would like to verify? Tomorrow? Whether WT was served, number one. Number two, what was the time they were moved out of the police station for production? Police station would have an entry. Whether it is here or not, the police station would have an entry. Is it not? In the arrest memo, it is shown as 10:10 at 11 p.m. FIR says that I have intercepted at 2 o'clock. So from 2 o'clock, they are in custody. Is it not? On 10:10, they are in custody at 2 o'clock. So 11:10, you have time till 2 o'clock. Find out. Tomorrow, sir. List the matter again tomorrow, allowing the learned APP to have his instructions.
29.
Yes, madam. There is a procedural absence, therefore there will be. The bail conditions would be strict. That we can attend to, but when the procedural lapse is there, can we fill it up? We can only build the wall. You will have to run the kitchen. Okay. Heard Ms. So-and-so learned counsel appearing for the petitioner, also heard the learned APP, Ms. S.H. Bora. Although the earlier bail petition preferred by the petitioner had been rejected by another bench of this court, by the order dated 13/3/2026, the said bench had requested the matter to be listed before any other bench without him. Before any other bench, full stop. Accordingly, this matter has come up today before this court. Stop. This is a bail petition under section 483 of the BNSS 2023, praying for bail in connection with, you will find it at page 1, the second paragraph. The learned counsel for the petitioner has submitted that where was that? The arrest memo? How many petitioners are there? That as per the arrest memo, comma. Yes. Hmm? Huh. I'm not understanding. What? Who is Nawaz Sharif? Who is Nawaz Sharif? Hmm. Where is it? Page number 30. Where do I find Nawaz Sharif there? Where is Nawaz Sharif there, madam? Ah, it is at page 32. Not the vernacular, the original vernacular has to be in Assamese. Huh? It is at the top, it is Muhammad Nawaz Sharif. Hmm? Son of some Kabir. What is the fault in this arrest memo? What is the fault in the arrest memo? Are you taking up any fault in the arrest memo? No. What is it? Huh? Found 2 numbers of packet. The learned counsel for the petitioner has submitted that the where is it 47 notice? Page number? This 101 is of whom? 101 is page 101 is what? What is this page 101? Huh? What starts? Page 47, notice of 47 on Nawaz Sharif, there is a signature. Huh? What about at page number 98? The signature is there. The learned counsel for the petitioner has submitted that. Madam, we are not satisfied. Kindly come to page number 97. Page number 97 is what? And 90, what is page number 98? You have put it up and down. What is page number 98? Nawaz Sharif. So Nawaz Sharif has been told his grounds of arrest. Tell us. And what about Wahida? You are putting up the papers in a haphazard manner. How can we do it? This TCR has come. TCR is there, some TCR খন দিয়ক এটা বিল কৰিবলৈ ইমান দেৰি লগালে কেনেকে হ'ব তিনিটা বাজি গ'ল The learned counsel for the petitioner has submitted that the notice under section 47 with regard to it has your thumb impression, madam. It has your thumb impression. We are not satisfied on the 47 part. No, but if you have made a statement in the affidavit that the 47 notice had not been served upon you, you have made a false statement. You will have to dismiss your bail petition. Another ground is a separate thing. Have you stated in the affidavit that the 47 notice had not been served upon you? We are just what you are asking you just tell us that much. We'll try to find out the best possible way to solve the problem. There, LTI, RTI could not find. This copy does not have it, but Parashar, help us. Just a minute. এইটো চব এইটো ডাকটো মাৰি দিছে এইটো ডাকটো মাৰি দিছে দেখিছে RTI হয়নে ইয়াত ডাক এটা মান আছে দেখিছে লিখিছে দেখকচোন we may have to call for the originals 47 served in your affidavit you have said 47 not served no once you make a false statement on affidavit why should we allow These are RTIs or LTIs something. These are scan copies so that mark has come. 47. 47 you have been served. Both of you have been served the copies. No, the petitioner has to say that I have not been served. I have not seen 47. Please tell that to the court. Then you will tell. But here you are making up that story that it has not been served. It has been served. And once there is a false statement on affidavit, 48 not complied, that we will look into. But when a false statement on affidavit comes regarding 47, we are trusting every petition which is being placed before us. The moment we start to show slackness, these are affidavits which we believe, is it not? One statement in the affidavit we believe. In the affidavit there is a statement. The investigating officer, but the grounds of arrest were not communicated. We'll take it up after half an hour. Think what you want to do. If you want to come up afresh with the correct set of documents, there may be some consideration. If you do not come up with the correct set of documents, if statements are being made on affidavit which are not telling with the records, we will not have an option. We'll have it after some time, half an hour. Take your time. Think it over. Yes. It was served. Oh yes, sure. Uh-huh. No. Where is that WhatsApp business you were saying that judgment? No, you said that there's a judgment saying that WhatsApp business will not do.
Right, there's a positive direction for them. WhatsApp is. Sometimes there may be link failure. So we have to assume that the WhatsApp was on throughout that. We have to. Maybe it's from London also. So we'll have to assume that the WhatsApp was on. Second, we'll have to assume that direction.
Where is that?
Is para 11, direction number A. The only ground that I'm indicating is whether the WK message was communicated by the police or maybe at a belated stage.
Seen that? Huh. And in the WhatsApp, the other person says mil gaya. That is not beside the point, sir. That is the main point, whether they had information or not. How can that be beside the point?
If the lordship holds that this is the compliance of section 41, all the states and the union territories must issue standing orders to the respective police stationaries to issue notices under 41A oblique section 35 appear only through the mode of service as prescribed under CRP.
We do not find 47, 48 here.
Now, my lord, at the end of the day, this is a notice, man. This, while submitting, my lord, I said that this, I mean, this.
Any other ground, sir? Any other ground?
My lord, that's the only ground I'm indicating, my lord, as now, my lord. So, my lord, on marriage, my lord, if the lordship thinks the additional evidence which I have because this section 37, I'm aware of that, my lord, therefore, my lord, at the stage of bail, will what extent your lordship will go into, because my lord, my instruction is that this man was not carrying this bag, and it is at the end of the day 24 kilogram of ganja, not morphine or heroin. So my lord, this bag, then my client told me that they have applied for the CCTV footage, it will complete that it was not with him. Now that this CCTV footage was not with him. But photograph, I can make a man stand and I can make it. These photographs, I can make a man stand. Put some.
Yes. We are not, you said not on merit, so we are not on that part of the merit. Or on this thing, whether he was made to stand or not to stand, we will believe you to that extent. That it was not found on your body, but it was found in the train, and it has been said to be your bag. That is fine. But when your ground is of 47, 48.
The WP message was not being communicated to the family member. Now, to whom the WhatsApp they are saying that they are sending to the WhatsApp. This WhatsApp was sent to a distant relative.
So a person whom they do not know, a person whom they catch on the train, they will not find out the nearest relative. They will try to trace the farthest relative. Because you have not given any person, you have not nominated anybody.
Then this WP message is addressed to the family members of his district.
And this one?
His district.
How do we know it is the distant relative? Any statement made?
I will see the districts are different.
Any statement made?
Yes, on page 21.
My sister lives in a different state, different country. Doesn't make us distant relatives.
In that event, your lordship, I say that I may be given the liberty to file a request. I say, now I've come to know all these things, I'll take instructions and I'll say in fact how he's related to him and all this instructions I'll file.
But otherwise, 48 has been served.
That's how I've heard. But
Huh?
It will not come, my lord, that subset has been overthrown.
What to do? What to do?
Then with liberty, file afresh. We file also a file.
Mr. Biswas, learned counsel appearing for the petitioner, has submitted that he would pray for the that he would pray for the liberty to withdraw this bill petition in its present form to file afresh. Bill application is closed with the liberty as aforesaid. The CD would be returned.
Copy it.
Yes. Huh? Hmm. 15/3. 20? False. 15th is a Sunday. False. We'll record it. We'll ask for the lower court. Why is a false statement given to the court? Hmm? By granting him the bail. How many days you say? 5/3, 15/3, 10 days. Please.
Fourth paragraph. Please find in the FIR fourth paragraph. But the last two lines, during the search, a total of 19 files wrapped in a black polythene packet containing suspected heroin,
Hmm.
which attacked the right side booty were recovered from his possession.
Hmm.
The suspected person was apprehended on the spot, identified as Asgar. I am not Asgar. Asgar obtained bail, he got paid from the High Court. Now, my lord, now the forwarding report, my lord, page 18. It starts from page 7. Page 18, my lord, the grounds of arrest, paragraph number 2.
Hmm.
The reliable source information and statement recorded during investigation revealed that the taking is a regular and prime supplier of drugs to the different vendors operated within the jurisdiction of authorization. This is the allegation. And no contraband has been recovered from him. The person from whom the contraband was recovered was granted 3 times. Mother, at this stage, I am praying only for interim matter. Let the record come by the situation. I am there, but it's what we may bring at my case. I'm going to say, nothing has been recovered. That statement in the charge sheet is not yet submitted.
On 15th of March. Hmm. Sunday, where the
My statement at the bar may be recorded.
They will be considered as a recipe when it is seen.
Is highly shaped. Because my lord, the personal search, my lord, was not searched before the magistrate or the magistrate office. Probably nothing has been recovered. The main is to type for probably not. The search before 4 independent witnesses. Section 50 of the Anti-Corruption says for it. Magistrate. Also only for interim bail, my lord, that is for 10 days, my lord.
But here they are saying that the accused was arrested on the spot.
Forwarding copy this one. Is certain in the FI and the forwarding as a either case energy. Same and then 19 miles now.
Nothing recovered from him. He has been arrested standing near his house. Hmm.
Case 29 of occupancy and inventory matter. Produced before the court matter.
Hmm.
Of that, after Alva.
Hmm. Okay, heard Mr. So learned counsel appearing for the petitioner also heard the learned APP. This is an application under 483 of the BNSS, praying for bail in connection with, you'll find it at page number. So the learned APP has submitted that the matter has been charge sheeted by charge sheet number 26. Full stop. The learned counsel for the petitioner has submitted that as per instructions received today also, comma, no charge sheet has been made available to the court of the to the learned trial court. Full stop. The learned counsel for the petitioner has submitted that the petitioner has been arrested while from the vicinity of his own residence, and there is no allegation of any recovery or recovery of any contraband or any other incriminating material from the petition. Full stop. The grounds of arrest show that during investigation, the petitioner herein has been suspected to be actively involved in illegal procurement, possession, distribution, and supply. The learned counsel for the petitioner has submitted that there has been no recovery made either from his house or from his person at the time of this arrest. Full stop. Having regard to the materials, to the submissions made, and the fact that there has been no recovery from the petitioner, and that the petitioner was arrested from admittedly from near his residence. After how many days of the arrest of the other person?
Wait, wait.
20th 12, when he was arrested on 5/3. Was arrested more than 2 months after, no, nearly 2 months after the arrest of the prime accused, and also the fact that the prime accused has already been granted bail by this court. This court is of the opinion that the petitioner can be allowed the privilege of an interim bail. Accordingly, it is provided that the petitioner shall be released on bail on furnishing a bond of rupees 50,000. From page 31, para 6, para 6, I mark in pencil, put up that part, and call for the case diary. Also, no, call for the trial court records. The APP shall also have specific instruction as to a specific written instruction as to the date on which the charge sheet had been submitted before the learned trial court. The continuance of the interim protection would be considered on receipt of the TCR. List again on 21st April. Huh? 21st April, 21st of
27.
Yes. Huh? Huh? 1:30 p.m. 15/3/2025. Okay. Where do you find that search was made on one? So I said that from the FIR. Huh? Huh? Next day when? 1:30. 1:30 custody. Where? One 3:15. 24 hours gone again. What do you say on the 47, 48? Why? What is the wrong in the format? What can you understand? What can you not understand? 47, what can you not understand? Yes. Because your signature is in English. We'll go into all that now in the bail petition. Conscious possession. What about the conscious possession? No. You were on 47, 48, we are on conscious possession. Stay there. Don't run away from the field. Stay there. 2 hours. In transit. 2 hours in transit. What is the distance from the place of arrest to the from the place of arrest to the police station? Yes, what do you say on that part? The 24 hour part, what do you say? 47, 48, we are not discussing. Saying what? Ah, 47, 48 already rejected by this court. So we forget that. Which was allowed? What is your name? All family. Is it all family? Then why again at page 54 it is another Tanjil? So they all appear to be family. This was because of the statement of the co-accused, not relevant. Then and who is this? Who is this rejected? 58. Page 58.
5 minutes below the course of investigation. The charges are confined. That time.
Page 58. Page 58.
Because my different parcels, because of that, that particular was not complied with. Circumstances, legal guarded. Then I had this is not we can get.
Some other case. Yes, page 64. The grounds, the conditions. Hmm? Heard the learned counsel appearing for the petitioner also heard the learned APP Mr. K.K. Parashar. Full stop. The learned counsel for the petitioner has submitted that the petitioner had been taken into custody at 1:30 p.m. on 15/10/2025 as if 15/3/2025 as reflected from the records itself, and the records would also reflect that he was taken out from the police station for production before the magistrate after his detention at 3:45 p.m. 3:15 p.m. on 16/3/2025. Accordingly, the counsel for the petitioner submits that the petitioner had been detained for a period of more than 24 hours within the police station, for which the arrest, the further detention of the petitioner has become unlawful and illegal. Full stop. The learned APP has submitted that keeping in view the recovery made from the conscious possession of the petitioner and also the manner in which the contrabands were being dealt with, the petitioner would not be entitled to the privilege of bail, even though, as per records, the period of 24 hours may have surpassed. Stop. The surpassed before his production, before the remand court. Full stop. We have, this court has considered the submissions made. It is seen that as per record, the detention of the petitioner exceeded a period of 24 hours before his production before the remand court. Okay. Then you take from page 69, para 16. Okay. Para 18. What was the recovery? Yaba. I have made a correction. It was ganja here, yaba, from the truck which was being driven by the appellant accused. Yeah. And you are? Which was being driven by. I'm making the pencil correction. You just do it, huh? Okay, okay. You are a resident of where? And where is this case from? Karimganj. So jurisdiction is not there. Of a Special Judge Karimganj. Karimganj will not be there, na? Wherever there is kacha silcha, just make it Sri Bhumi, huh? Will application disposed of? Yes.
Item 42.
Huh. Hmm. Yes. Okay. Hmm. Hmm. Yes, sir. Hmm. Now we'll close this. The heard Dr. Ashok Sharaf, Learned Senior Counsel, assisted by Mr. B. Sharma, Learned Counsel appearing for the applicant, and Mr. S. C. Kyal, Learned Standing Counsel, DGGI, appearing for the respondents. By the order dated 6/11/2025, this court had granted the privilege of a pre-arrest bail to the petitioner on certain conditions, and today a submission has been made by the Learned Senior Counsel that the petitioner has cooperated with the investigation. In the meantime, full stop. The Learned Counsel appearing for the DGGI has submitted that the investigation has been completed in the meantime, and the final complaint has been filed before the appropriate forum. Full stop. Accordingly, this court finds it fit to make absolute the interim protection granted to the petitioner by the order dated 6/11/2025 of the full stop. You'll be required to pay for regular bail when you appear for the trial. The petitioner would appear before the learned trial court on. No, मेरे absolute पे छोड़ दीजिए. Huh? AB closed.
47.
Yes, sir. Along with the FSL report. Why was the FSL report required? What is the flesh? What meat is it? Yes, sir. Tell us. Eh? Huh? There were two brothers. This is the case. Two brothers, one of them given AB. Yes. Not received. Has the petitioner number one, he has appeared? No. He's still running. The other one is still on the run. We'll allow the other one also to appear. No. ABCD. List again on when? Give us a short date. 6th of April. On the 7th of April, 2026. The interim orders passed earlier shall continue. The other fellow is still on run. Petitioner number one. Why don't you give him the aid? Yes, Mr. Parashar. Why don't you give him the aid? You are not being able to produce the diary. Hmm? Yes. 50.
150.
Yes. What happened to that notice on respondent number 2? Service is complete. What was the FIR? The service on the respondent number 2 is complete. PCR has been received. Why are you praying for anticipatory bill when, why? You were absent during the investigation. Investigation is complete, charge sheet submitted. এখন কোনটো কেছৰ হয়? কি হয় এইটো? অফ কি?
On 7/9/2020,
Huh.
and the FIR was lodged on 12/9/2025.
You are awaiting the end? হে? এখন কি হয় তেওঁক দেখুৱাওকচোন। এখন কি হয় তেওঁক দেখুৱাওকচোন। Scan copy of TCR called for. And in the next order, scan copy of case diary was called for. This case diary is available like that. Oh. It is. We'll appoint a. Huh? নাম এটা দিয়ক। Service of notice on respect of respondent number 2 is complete. That's it, কি হ'ব? Since none appears, appoint একেকেইটাকে ঘূৰাই থাকিলে আকৌ বেয়া পায় নি? হা? Oh. Appoint Miss M.K. Brown, learned counsel as the amicus in the matter. Petitioner, counsel for the. Huh? নালাগে নালাগে। কি ক'লো? Learned counsel for the petitioner to serve a copy of the petition on the learned amicus appointed today. Full stop. The allegations do not inspire an interim protection. Page number 3. Huh? Factual part. Oh, a note. There?
Who are residing in same place and they are neighbor like. Sometimes they meet at the time when she returned back from her school mother. But the family member of the victim were not happy with their relationship mind. Subsequently on 9/7/2025.
Let them go through the this thing. We'll have it when day after tomorrow. Day after tomorrow. 27. We are giving it to you in 2 days. You want it on 27th. List again on the 27th at the request of the learned counsel for the petition. 163. Why? Ah. It is an AB. Hmm? Why next week? Someone is running around. What is the FIR about? Charge sheet, huh? What is the FIR? Ah. Monday. Monday? At the request of the learned counsel appearing for the respondent number 2. List the matter again on Monday. Ah. কি है सोचो तो TCR है नहीं copy of TCR is there some TCR is there check it if it is half then we will ask for a full copy yes so he has not put any thumb impression. See 47 the notice which is given to the Nawaz Sharif it has his signatures. It has his signatures. So what do we do with Nawaz Sharif? When he makes an statement on the affidavit that I have not been given the copy and his signatures are there in the notice. For him, the statement in the affidavit becomes false. Don't go to Wahida, don't run here and there. We are on one person. Huh? 47 is where? Show us that. No, in the additional affidavit it is given, na? 90. What more ground do you need? You have been caught red-handed along with the seized contraband, morphine, while smuggling by concealing it in the vehicle bearing registration number 1A01AF 5409.
There is no any recipient signature or not. And there I have no full statement or not.
What is that affidavit you have said?
If previously also there, where is that granted? Something. And there is no any clear or RCA. It's completely invisible and which is the main my question. That I have taken the information from my member from people. You take to see that that's only coming to me. Just and I had this order for that pin number is
Heard Miss Mary Learned Counsel appearing for the petitioner, also heard the Learned APP. The Learned Counsel for the petitioner has submitted that the copy of the that the notice of the notice under section 47 of the BNSS served on the petitioner number 2 does not contain either her signatures or the right or the RTI. Stop. The registry to call for a report from the learned trial court, who shall after considering the originals available on record, send the report to this court as regards the availability of the RTI of the petitioner number 2 in the section in the notices served under section 47 of the BNSS. Full stop. There 48, how was it served? There is no. Then if 48 is not served, we have to grant the bill. If the 48 is not served, we have to grant the bill. Please strike it out. Strike out this order. Heard Miss Mehdi, learned counsel appearing for the petitioner, also heard the learned APP. Where is that 48 notice, madam? The learned counsel for the petitioner has submitted that the notice mandated under section 48 of the BNSS had not been served on any person who was a relative, family, or friend of the petitioner. Full stop. On a perusal of the scanned copy of the TCR, this court notices that indeed there is nothing on record to show that the notices under section 48 of the BNSS had been served on any person, on any family, friend, or relative of the petitioners. Full stop. It is a settled position. What is this? But there is nothing to show that this has been served. A family, friend, or a relative of the petitioner. List of the learned APP has drawn attention of this court to the WT message sent from the SHO Dilai PS to SHO Lilong, requesting him to inform the family or guardian of the above of the arrested persons. But there is nothing on record to show that what is the name? But here it is shown as, what is this, father? What is this document? What is this document? The approximation key. To show that the notice under section 48 of the BNSS was served upon any family, friend, or relative. Huh? That one I don't know. It has been held. No, it is settled position in law that when the notice under section 48 of the BNSS is not served in the manner prescribed in law, comma, the continued detention thereafter becomes illegal, and the arrested persons would be entitled to the benefit of in-law of daughter-in-law. But I don't think it has been served. I think it has been addressed. Or has it been served? You will have to find out from your. No, we are not. We are for the time being releasing them. In view of the above, comma, the petitioners shall be released on bail. It is also noticed that the petitioners have been in custody since 18/8/2025. We'll stop taking into account the length of detention and the failure of the arresting authority to abide by the mandates of Section 48 of the BNSS. This court is of the opinion that the accused petitioner can be allowed the privilege of bail. Full stop. Then from para 8, from para 8, page 115. ঠিক আছে? NDPS case number 2 আৰু হেতু মিলাই দিব। কি বুলি কয়? Section. বাকি এইকেইটা condition দি দিলে হ'ব। It is, however, provided that in case the investigating authority or the prosecution comes to a finding that the notices under Section 48 of the BNSS had indeed been served upon any family, relative, or friend of the petitioners, comma, the same shall be brought to the notice of the trial court, and upon such fact being brought to notice, the trial court would be at liberty to pass appropriate orders, comma, cancelling the bail granted. Full stop. Bail application disposed of. If you can show that, when 48 is not complied with, goes. And if you can show that 48 was complied with, we have given you the liberty, move an application there that 48 was complied with 2 hours prior to the production. Show it to them, they'll cancel the bill for the time being granted. Yes.
That case, my lord, is that, my lord, from the past, my lord, 2 persons clear, my lord, arrested, my lord, one was from the scene, another scene, and from my lord. Persons clear, my lord, 2 persons clear, my lord, examined, there to be, my lord, there are contractor and the my lord, driver. No ID from my lord.
Yes, sir. What do you say? Conductor and driver, they are saying that we saw them come up with the bag. The conductor and driver says he has seen the accused persons coming onto the bus with the bag. The bag contained contraband. They are now convicted. Since the appeal is not being taken up, he is praying for bail. Judgment is of 2023. 2.5 years. আঢ়ৈ বছৰ 7.
If prima facie will accuse that will they will be acquitted
Hmm.
or half of the accused will be. In both the cases will
Why? That is his whole case. There is no proof that they are the driver and the handyman. That is his case. Hmm? So I may be considered. Huh? There is no evidence led that they are the driver and the handyman. It is simply the police statement. It is simply their statement. Driver and handyman has to have. Hmm? He considered that other than the driver and the handyman, he did not make any other independent witness.
with all their bags.
Hmm.
This person left the bags in the bus.
Is it not presuming their guilt? If it is not their bag, they will not take it down. As simple as that. Hmm. Mhm.
He was present. I request all the passengers to get up from the bus with their bags. The study is going. And these two persons left their bags in the bus.
So when the recovery is not from the person, but below the seat, the driver and the handyman's evidence will do. In a criminal case, the first question is why to believe. In a POCSO case, you can say why to disbelieve. In prevention of corruption, you may say why to disbelieve. But in NDPS, not from their body, not from anywhere, from under the seat. So, huh?
They cannot say how much, which bag was belongs to the city. Where it was kept, who has kept the bag under goods on top of the
When we had assured him on the next date we'll take up the IA or the appeal. Huh? We'll take. IA এখন দিয়কচোন। The trial court records have been received. Huh? Were you on interim bail during the, when were you arrested initially? First arrest? Date of offense. You were arrested on date of offense only. Huh? 742023 almost. We'll allow it today. The trial court records have been received. The learned counsel for the petitioner has submitted that the respondents, the appellants have already undergone a period of around 3 years of incarceration from the date of their arrest. Full stop. The learned counsel for the appellant has submitted that there are enough and more grounds for the appeal to be considered in the positive, and there is a sufficient chance that they may be released, they may be acquitted in the matter. Full stop. The learned APP has submitted that the appeal may be taken up for consideration. Full stop. In the having gone through the trial court records cursorily, and also in view of the fact that the appellants have already undergone nearly 3 years of custody. This court is of the opinion that the petitioners can, that the appellants can, petitioners can be allowed the privilege of bail during the pendency of the appeal. Accordingly, the petitioners shall be released on bail on furnishing bonds of rupees 50,000 each, with 2 sureties of the like amount to the satisfaction of Special Judge Karbi Anglong. Special Judge NDPS Karbi Anglong, the learned trial court shall have the liberty to impose such conditions upon the petitioners to ensure their surrender before the court in case the appeal does not succeed. I disposed of. Then in the main appeal, you write, list this matter for hearing on 28th of April 2027. 2026. Dirk, next to. কি ঘটনা বুঝিয়ে চেষ্টা করেছে আমাকে হ্যাঁ হ্যাঁ what is the, where is the order? Impugned order is where? '23? No. Huh? Page 10 onwards. What is the final order? So you are supposed to pay how much? Total of 4,000 per month. And how much have you paid till now? How much have you paid? We'll dismiss it. Eh? No, no. We are not on that. What we want to know is there a stay in the matter? No. There is no stay. This has not been even registered till now because the IA has not been. Now, when was the order passed? So be it. So be it. You go for a cancellation of this order, recall of this order. But from 2023, you have not paid anything. 2023, there is a lockdown. June 2023. Huh. Huh. Ex parte order we are not concerned with. When there is a no stay, why are you not paying anything? And then there is a warrant of arrest also. There is a warrant of arrest also. Yes. Page 20, what is this? Page 23? What is page 23? Huh? Hmm? Area amount, they have said no area required. Page 19, from the date of the order. Huh, pay it. Pay it and come back. How much will you deposit? From January, it is nothing. Huh? Hmm. You can earn inside those bars. There is a provision of earning behind the bars. Bamushakkad. Rigorous. You are paid for rigorous. Hmm? No, you are dismissing it today. Both of these. What areas? The trial court gave you the best benefit. I consider you to be a person who cannot pay from the beginning, so pay from date of disorder. Then for 2 years you have not paid. Then you have come to this court to say that no, I will not pay for these 2 years also. Is it not? That is what you are saying to. That is a good way of haggling, that if I will not pay, then I will go to jail. She will not get paid, I will go to jail, so give me something. Huh? You are ready to pay. He is on legal aid? No. He is not on legal aid. He has the ability to pay. Yes. What is your objection? What do you say in that?
Then property. He did not know, he did not contact his lawyer, and the lawyer did not let him know what was happening. Whereas it is his duty to do it. After 2 years, when this execution cycle.
Heard, Mr. Sorry. Either you pay or you go to jail. Heard, Mr. Yunus. Heard, Mr. Yunus, done a counsel paying for the petitioner. If that is the attitude that she will not get paid and I will go to jail, so be it. Then it has to be so be it. There's no other way. For 2 years, he has not paid anything. That is not your prayer in the revision. That is not your prayer. Heard Mr. A. Rashid, learned counsel appearing for the petitioner. Also heard Miss M.K. Brown, learned counsel appearing for the respondent. Full stop. This is an application praying for condonation of 688 days in referring the present accompanying criminal revision petition. Full stop. By the order impugned in the criminal revision petition, the petitioner was required to pay a sum of rupees 4,000 as maintenance to his wife and children on and from the date of passing of the order by the judicial magistrate first class Golpara, that is from 21/6/2023, full stop. It has been submitted at the bar that the petitioner has not paid any amount till date, and the only reason given for praying for condonation of the delay is that the petitioner did not contact his counsel, and the counsel also failed to inform him. Full stop. The court is not satisfied with the grounds given. Full stop. The court is also not satisfied in the manner in which a maintenance granted by a competent court of law has not been satisfied till for 2 years from the date of the passing of the order, and then this court has been approached, and even when there is no order of stay, the no benefit has been the respondent number 2 has not been able to reap the benefits of a successful litigation. Full stop. In view of all the above, this court does not find the interlocutory application for condonation of delay liable to be entitled to be entertained. Full stop. Accordingly, the same is dismissed. I dismissed. Criminal revision to the head list here no hobo. Ekwe no hobo. Do I need to pass? In huh? Not require anything.
16.
Yes, sir. Hmm? Hmm. We have to await service on the respondent number 2. But the service report says neither ID card. You have taken it by speed post. It has to be taken by speed post, yes. Await service report on the respondent number 2. List again on 31st of March. Ah. Hmm. The learned AVP shall call for the scan copy of the case diary. For the updated CD. Because it was returned because holding it here was not serving any purpose. Is there a bar? He must have done, they must have done something good. What did they do? When a truck was caught with the bulls, they had sold off one of the bull to someone else and then seized the others. Huh? Free for. Huh? We kept it on 31st of March for service report and updated CD, है ना? Yes.
64.
Hmm. We passed some order. Yes. Hmm.
That is the completed with 6 weeks. Nothing has been done today.
Hmm.
By the first message has been presented. Until the presentation is done, all I have been can you also last part?
No, what orders are we required to pass today? Quash to quash and set aside the order of the censor removing the petitioner from the Gaon Panchayat. So the order removing you from the Gaon Panchayat was? Huh. Huh. Hmm. Yes, sir. Huh?
This form,
Cannot be exercised by the DC. Huh. So?
only cannot be exercised.
Huh. That is what we have said. Huh.
But only way to release the restriction.
So the DC's order is not there. The Deputy Commissioner's order is not there. We gave you the liberty to hold an inquiry. You did not proceed with it for the within 6 months. What is the consequence? Gone. So now what happens? Once the termination order goes, what is the consequence? We'll record it. Huh? Once you are removed and then you are again huh? Huh? Even when you are taking back charge. That is only
Why you not taking charge?
No, she may fix the matter another day. I'll place that judgment.
Not just that is by
it is not about that. We are going to record your statement, subject to you saying so, that the termination order set aside by this court. Deputy Commissioner has been held have to have no powers to hold an inquiry or to even remove him or whatever, cancel his candidature or whatever. All that being done, he remains the elected candidate. Therefore, now, since he remains the elected candidate, you take further processes to commission him the oath and you will do it day after tomorrow, or we'll hold you up in contempt. Code of conduct is on this thing. So you do it after the code of conduct. It has to be done after the code of conduct.
policy is shown about development and not government.
How will the code of conduct come in? Where is that code of conduct orders? Let us see. Tomorrow can we have it, sir? I understand, but we must have a copy of that code of conduct. Or what we can do is we can direct them to do them, ask them to do it forthwith, if there is no no legal impediment. Is it not? This interlocutory application has been preferred by the is an interlocutory application maintainable in a disposed of writ petition? Huh? No, that your prayer clause does not contain what you have said. Your prayer clause does not contain what you have said. This interlocutor application has been filed by the applicants who were the original writ petitioners in WPC number 4683 of 2025, which was disposed of by the order dated 4/12/2025, full stop. By the aforesaid order, the respondent authorities, no, this court had set aside the order dated 16/7/2025 passed by the Deputy Commissioner Gwalpara, removing the petitioner from the post of Gaon Panchayat member of Ward 1 number Ward, Nathongdonga, Tiapara, Takimari, Haguripara, Gaon Panchayat in the district of Gwalpara. Page page 79. The consequential corrigendum dated 19/7/05 insofar as it related to the petitioner was also interfered with. This court had further given the liberty to the District Commissioner Gwalpara to proceed with the inquiry, if so deemed fit, regarding the allegation leveled against the petitioner in accordance with law. Full stop. The same was, however, required to be concluded within a period of 6 weeks from the date of the order. The order was passed on 4/12/2025, and therefore the period of 6 weeks has elapsed on in January 2026. Full stop. It is stated at the bar that no action has been taken to continue the inquiry against the petitioner. Full stop. It has been stated by that is okay. In the it has been stated by Mr. So-and-so and Mr. So-and-so, learned counsel, appearing for the. You are appearing for? And Mr. So-and-so, learned counsel, appearing for? One. That in a more recent judgment of this court, it has been held that the Deputy Commissioner would have no powers to interfere with the elections of Gaon Panchayat members, and therefore the learned counsel for the respondent submit that the Deputy Commissioner could not continue the inquiry, although liberty was granted by this court. Full stop. This court finds that since the order passed by the Deputy Commissioner was in any view of the matter not sustainable in law and had been set aside by this court, and there is no now and the respondents submit that no inquiry is now being proposed against the petitioner, the prayer of the petitioner for being allowed to forthwith take over the charge as the member of the so-and-so Gaon Panchayat should be immediately addressed to by the respondent authorities. Full stop. Accordingly, the respondent authorities are directed to take immediate steps to make arrangements for the petitioner to take charge of the post of Gaon Panchayat member from so-and-so if there is no other impediment in law. Full stop. IA is accordingly disposed. In a more recent judgment বুলি য'ত কৈছিলো তাতে তেওঁ WPC নাম্বাৰ দি থৈ দিছে if there is no legal impediment to the লিখিছে তাতে লিখি দিয়ক due to the code of conduct if any imposed. one of our senior benches has said that this man is on test here. The others only make submissions. Yes, he's trying to put up a very honest case. Will you concede now? He wants it to go back. Hmm. No, we can interfere to the extent that there is an order of the court, but we cannot become the court. So therefore, we can set aside that order of the court. The complaint we cannot set aside. Yes, yes. Yes. Hmm. Hmm. Each. Huh. Hmm. 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 So your submission is that this protest petition, on the basis of this protest petition, the Hmm.
what is essentially is that in what proceed because of my additional procedure requirement. The argument requires the sketching. Maybe accepted. When an order is proposed, if the order is bad, it will. It not going to merits. 60 of application. I think once the way it did.
The issue that he is raising is, no, does the protest petition have enough material to be even considered as a complaint? So if it does not have enough material, it will be only taken up as a protest petition. Therefore, the best that can be done is send it back for a reinvestigation. Could cognizance have been taken? That is what he's trying to say. If you send it back, if you accept the protest petition as a protest petition, send it back to the investigating authority. Done. You don't accept the protest, you accept the final report, done. But could you take it up as a complaint? There it says that in a complaint where that this thing is not taken. Two.
Now, if you go into the business, methods now, this argument
No. Let us put it another way. Because what you are arguing is what you will convince us. We have also some idea and we need to be convinced on that. We put it the other way. Cognizance having been taken, this is the technical flaw is where you are starting. We will take it one step before that. Could the process of taking cognizance have started? Or should it have been treated as a protest petition and decided then and there? If it had the materials of a complaint petition to be treated as a complaint, thereafter whether cognizance taken, how to be taken will come. But his case is that this particular page 26 to 28 does not have any material, any semblance of a complaint, and therefore the question of going to take or not take a cognizance could not have arisen. Only if it has some semblance of a complaint, then the court will take a decision whether I take a cognizance or not. If I want to take a cognizance, I will call for the evidence. He says that was wrong. First, that is wrong.
and then proceed.
Hmm.
Once the consideration part is there,
It is not there is his case. It is not there.
see, essentially value law, therefore there is that address it on the report on that, it cannot be taken. Correct. What even if it is a complaint, it has to take cognizance. Otherwise, the jurisdiction court cannot proceed. Rightly, wrongly, a cognizance has to be taken following the procedures of law.
He says the cognizance could not have started.
He said,
No.
Round A. And I'm saying that if the cognizance is taken, then only it proceeds.
Yes.
Cognizance because taking or not taking must be clearing the other side. Taking or not taking, both. Not only in my favor,
before this can be taken as a complaint to take cognizance or not, this is not a complaint petition filed. So now to take the color of a complaint petition, it must have some attributes. There will be some attributes. He wants us to decide whether it had the attribute to be taken up as a complaint petition. Hmm.
Technical division. Only one design one is there. When we are challenging of an order of cognizance, and the argument advances, it could not have any complaint simplicity.
It could not have, it did not have the nature of a complaint. To be considered. Hmm.
Yes, only. Court to decide even on that issue needs to hear the answer. Even to decide on that issue, apart from that.
It is your protest petition, he should have been heard. It is your protest petition, so he should have been heard. Page 5 of what?
He is saying that he filed it, thereafter the cognizance was taken.
Who filed it?
I filed it.
Ah,
Thereafter the cognizance was passed. Like he saying, that the authorized court ought to have exercised the jurisdiction and ought to have heard even then. Let him get it. Go back.
on the protest petition.
So, Congress could not have been taken. In fact, I'm in his camp. But he is to say that the genesis is decided by a watch. That will not. He is trying to have a date.
So difficult for three of us to stay serious. Yes. Uh, uh, But the protest petition has to be decided.
Yes.
Hmm. No, they can file a complaint once the protest petition is rejected. Hmm. That even the complaint would be rejected.
These parties. We might put petition the protest petition.
The paragraph 12 is what he's saying should happen. Paragraph 12 is what he's saying should happen. However, we leave it open for the magistrate to treat the protest petition as a complaint and proceed in accordance with law. Seeking that it should go back for a reinvestigation. So either it can be allowed or it can be disallowed. It can be allowed or it can be rejected. In the case of a rejection, he will have the liberty to file a complaint under 200 CRPC as it was then. And in case it is that protest petition is allowed, the re-inquiry will take place. But there can be no question of taking a cognizance. That is your submission. And your submission is, we have not agreed to him. We have not agreed to him. Your submission is that whether or not the cognizance was properly taken will be seen by this court. If not properly taken, matter will be remanded back to the trial court to take a decision whether to take cognizance or not after hearing him. And your case is that it cannot be, the present protest petition does not have the attributes of a complaint, and therefore that stage of cognizance or no cognizance will never come. He says it should be left open to the lower court to trial court to decide. We'll just push it back. Yes or no of what? Whether it's a, but whether you have not said a single sentence on whether it can be treated as a complaint or not. Now, whether it can be treated as a complaint. On the attributes that he has shown, that this protest petition does not have a list of witnesses. It has got nothing in it, with only a prayer that please send it back.
Trial court would say yes or no after hearing him. On that point, I am there.
Yes or no to what?
From this part.
In a protest petition, where is the question of a cognizance? Unless it becomes a complaint. Now he says that this petition, that is the argument we are trying to hear from you. He says that in the facts and circumstances of this case, this particular protest petition cannot take the form of a complaint. And that was not.
To be argued before pass an order thereafter.
No. Whether when you have not prayed before the jurisdictional court to take it up as a complaint. No.
The question of compliance of this new code.
The other things will not come in. You are saying that it will be totally upon him to take a decision after hearing him to treat it as a complaint or not. In case he takes it up to treat it as a complaint, then the question will come how to take up the cognizance. That is your argument.
Procedure, yes,
yes, if it is wrong, then he has to be.
Procedure part with respect to taking cognizance was wrong. That there is no choice in that regard. With respect to complaint. And one important aspect when a protest petition is filed is only the complaint is not the accused.
The moment his argument is the moment the jurisdictional court wants to take it up as a complaint, he has to hear you before that. He says that argument has to be made before the jurisdictional court, not before this court. Huh? So what you want is a shut here, and what he wants is a protest there. So whether it shuts here or the protest goes back.
Doesn't take away the rights to file a complaint.
In a protest petition, the picture is good.
Hmm.
You need not be heard.
Huh.
Now the law has changed. If I proceed, you must be. No right.
No. Even if while treating it as a protest to direct an inquiry, a further inquiry, he need not be heard. He need not be heard. But then the moment he wants to treat it as a complaint, not send it back for further investigation, but I'll continue with it. That moment that he wants to take it up, is then he has to be heard. That is how we understood the law. That is how we understood our powers. He's taking us one step more. I understand. But that would, I think, that would also have to be decided by the jurisdictional court as to whether to treat it as a protest. Now, what orders to pass on a protest petition? If he wants to treat it as a protest petition, matter ends there. If he wants to make it into a complaint petition, that moment you have to be heard, whether it can be converted into a complaint, even to take cognizance. And if he wants to take cognizance, then the other steps before taking cognizance has to come up. Huh? It does not have the attributes of a complaint, and therefore, without hearing you, the court should have treated it as a protest petition and finished it there, either allowing a further inquiry or not allowing any further inquiry, whereby he would have the liberty to file a complaint. But then on the but on the consensus we had yesterday, the stay was only till 4:30. So as of now, there is no stay. As of now, there is no stay, Mr. Deori. Last 20 minutes. Thank you. We'll pass our judgment inside. It will take some